state of Florida, murder, suicide, any crime, not a disclosable event. Also, anything related to the health of the individual, COVID, AIDS, cancer, whatever, does not get disclosed either, because that falls under HIPAA, and that is the health information of the individual, and they have a right to privacy. Now, what Cheryl touched on earlier is asbestos. If the guy died from asbestos, we would disclose that there's asbestos in the home, but we would not disclose that someone died from it, because it does not affect the home. And what you guys all did very well on is there's a difference between what is legal and what is ethical. And ethics are a fantastic gray area. We can all have different ethics and opinions. We would all be right, we would all be wrong. But the law is very black and white, very clear on this. And it comes down to what is known as material facts. Material facts are facts that affect the physical condition of the home itself, and not stigma. So you use that buzzword appropriately. So if it's a high crime area, what is high crime? What is high crime to you? What is high crime to me? Schools are poor. Well, compared to what? What is a poor school? What is not a poor school? None of those things fall into the property itself. So the question that I ask, and this is a ridiculous question, is does the house know? Like if someone was walking in, an appraiser's walking in to a home and they don't know anything about the neighborhood, that's fine, because what they're gonna go on are the comps, and they're gonna go on the actual condition of the home itself. Does an inspector know, like if there's a blood stain on the carpet, you would disclose that the carpet is soiled, but you wouldn't disclose anything beyond that. There was a landmark case, Johnson versus Davis, in 1982. It went to the Supreme Court in 1985, and this is what all disclosure law is founded on in the state of Florida now. It basically states that anything that is, the seller should disclose any material facts to the buyer. This is a fun case because it was the Davises that were buying the Johnsons' home. The Davises asked the Johnsons, any problems with the roof or anything like that? No, we had a roof leak, but we fixed it. We had a window leak, but we fixed it. There's no problem. The contract at that time stated that if there were any roof issues, that the seller would pay for them. But it's very broad language. After a heavy rainstorm, they went back to the house and noted that there was a roof leak and also a huge leak around the window. Water was pouring into the house. So they had a bunch of roofers come out, and roofers all said that there's no way the roof could be saved. It needs to be replaced. It's shot. And the window was patched poorly, but needs to be completely replaced. The Davises had not yet closed on the house, and instead they decided to back out of the contract. Now, back then in 1982, there was no, the contract was completely different. So they actually lost part of their escrow deposit. They had $31,000 in escrow because they were buying a home that was $310,000. $310,000 home in 1982 would be the equivalent of like a $1.something million house today. So this was not an average home. This was a high-end home. And what's hilarious to me is that the sellers, the Johnsons, were the ones that sued the Davises for backing out of the contract. So it went to court, and the court found in favor of the Johnsons, the sellers, and said that that they should have retained more of the deposit, and that the buyer should have continued with the sale. They were in breach of contract. It went to the appeals court of Florida. The appeals court had some sense, and they said, no, this is ridiculous. The seller clearly was trying to hide these things with the home, and they were acting fraudulently. And so they returned the Davises' money to them. It went to the Supreme Court. The Supreme Court held it up and basically said that you must disclose anything that you're aware of. Otherwise, it's fraud. If there's a problem with the home and you don't know it, you're not in any trouble because it's not fraud. You're not covering anything up that you shouldn't. There was another case similar to that time. That was Rayner versus Wise Realty. Wise Realty was a brokerage in Tallahassee. The listing agent had a termite inspection done. The termite inspection found that there was active termites and damage and wood rot. He hid that report from the buyers. Instead called another termite company who he was friends with and said, hey, will you just write a letter for me saying that there's no issues with this home? And so that company wrote a letter saying, yeah, there's no issues with the home, it's all good to go. After the buyer closed on the house, they realized that there was an active termite infestation, tons of damage, wood rot, and then later it was determined that all these facts were hidden. Now in 1980, the law of the land was this Latin word that was caveat emptor. Anyone know caveat emptor, what it means from real estate school?
Buyer beware.
Buyer beware, which means that it's up to the buyer to figure out everything they got to figure out. And the contract, is what it is. The buyer has a chance to do their due diligence and that's it. The courts later decided that that's true. It is buyer beware. However, it's not fair that the buyer be hidden from essential details of the home because that's fraud. And so those are two landmark cases. And so that means that if you as an agent know about something that affects the value of the home, you are required to disclose it. And the seller is required to disclose it as well. So those are very important, case law to know in Florida. In other states, it's not the same. In other states, they have to disclose everything. If there's a murder, if there's COVID, whatever, they disclose everything. Florida is very different than that. So we're still, pretty liberal when it comes to purchasing. So the seller's disclosure is a very important document. It must be filled out to the best of the seller's knowledge. Again, if the seller has no actual knowledge of it, then it can't be used against them, because the court would have to prove that they knew it and they purposely hid it. One of the things that drives me crazy is when we get a seller's disclosure that's crossed out and says seller never lived in the home. Mm-hmm. That is bull and is not a valid seller's disclosure. And I always tell my clients not to sign it, because even if you haven't lived in the home, if you're the landlord of a home, you know if the roof has leaked. You know if you've replaced the air conditioner. You know if there's something that happens because you're the one that's paying for it. And so it's not enough to say that. And I feel, yes.
Is there an exception for bank-owned properties? Because this actually came up in one of the mastermind groups the other day.
There's not.
I mean, in other words, the bank can say they have no knowledge of anything about the house.
The bank would be able to stand on the fact that they don't have knowledge, because they don't have knowledge. Right. But if someone like a landlord is a perfect example. So where I see it is they have knowledge of the house. They've owned it for 6 years. Mm-hmm. They can't just cross it out.
Right, because they'd have a tenant complaint, so
they would know. Like if there was a storm and they filed an insurance claim, mm-hmm. they would know because they would be the ones to do it. And so those are things that will come up that you want to make sure to be aware of. And agents will try to tell you otherwise because they are either trying to commit fraud themselves or they just don't know any better. And so it's very important that you stick to your guns on this and try to get as much information as you can ahead of time. When it comes to disclosing, you want to disclose if there's any code enforcement violations, and that's different from an open permit. So sometimes if there's like an HOA violation, that needs to be disclosed because that can actually hold up closing, or a city code enforcement that needs to be disclosed. So you're all familiar with the seller's disclosure, right? We've all seen it, we've all filled it out. There's a box on there that says, I don't know. And I don't know is a perfectly acceptable response if you truly don't know. So that's when it comes to disclosure. The next forms are the HOA. It is the responsibility of the seller and the listing agent to provide as much information as they can to potential buyers about the HOA. It's not a bad idea to call, ask them if they have transfer fees or initiation fees, or whatever they want to call it, because that is something that will pop up at a closing that will get a buyer upset. There are some communities that I'm aware of that have like a $3,200 welcome to the neighborhood fee that a buyer has to pay. And so that is a fee that you do not want to be surprised with on the day of closing. You don't want your buyer to be surprised with that. And so if you have the listing, do your best to get that information from the HOA. Do your best to get the covenants and the restrictions. Attach it to the MLS so that it's public for everybody. If there is an initiation fee, there is a spot now in the HOA disclosure on page 2 where you can write in what the one-time fees are, to the buyer. If you don't disclose the fee, the buyer still has to pay it, because again, the disclosure is just letting you know everything that is available at the time. But I've had closings that almost didn't happen because the buyer didn't want to pay the extra $500 or whatever, they weren't aware of it. And so that's something you want to try to mitigate. If you, at the end of the day, if you're on the buyer side of it, it's also your job to get as much information as you can for your buyer. If you can't get it from the seller or the listing agent, you can call the HOA directly, try to get the forms and everything, and try to do the best you can so that the buyer has all the information they need, especially during the inspection period. Because you might have a buyer who has a boat and they're planning on parking the boat in the backyard, and the listing agent and the seller are like, yeah, that's no problem, people do it all the time. But the HOA restrictions may say something specifically against it. And so at that point, you want your buyer to know so they can weigh for themselves how they want to proceed. We all know that there are some restrictions that HOAs have in writing that they never enforce, but we can't assume anything in that situation. The next disclosure is the condo disclosure, so that has to do with a condominium. Real quick, difference between a condo and a townhome. Anyone? Difference between a condo and a townhome.
Townhome, you sometimes also own the land that
Yeah, perhaps, And the condo, do you own the land?
No,
No. So
shared common area, I think.
Right, so both will have shared common areas.
Yeah.
Typically, townhomes, you're right, will have a little bit of actual land associated with them, even if it's like a point something. Also is neighbors above or below.
Yeah.
So if you have a neighbor above or below, it's safe to assume it's not a townhome.
Mm-hmm.
If you only have neighbors left and right, it's assumed, it could be a condo still, but it could be a townhome. Agents will enter a condo as a townhome. I've seen agents enter a townhome as a single family.
Yeah.
I've seen everything enter. I've seen things misentered.
Right.
And I've seen some HOAs that are called Southampton condo, but they're not condos anymore. They're now townhomes. And so the name itself doesn't really mean much. And so you want to do some more digging as to how everything is drafted. The tax record will help in the way that it will be fee simple versus condo setup, and that's how the taxes are done. So fee simple means that you own the land, and co-op or condo means that it's shared common space. So you want to make sure you have those together. Very important, condo fees are almost always higher than townhome fees, because most condos will have the outside, like you're only paying for the interior space, right? So the outside of the building, the roof is covered by the condo association. Some townhomes are set up like that as well. So some townhomes will take care of the exterior and the roofs. It just depends. Financing is a huge difference between townhomes and condos. So you want to make sure that you have all that up front. Nothing worse than having someone fall in love with something they think is a townhome, it's really a condo, and then they can't get financing on that. And so again, you want to rely on the disclosures as much as you can, but you also want to be doing your own due diligence. The seller's disclosure should be a baseline for what to expect, but you should never use it. Next question. The buyer is accepting the home as is. That means that I don't have to disclose anything to them, right? Or doesn't?
Does not mean that.
No.
That doesn't mean that at all.
Correct.
You have a requirement to disclose all facts that would be normally observable to a
Right.
regular person.
Right. Because as is means something completely different to what the general public can believe it means. If you're buying a car as is, you're buying a car with no implied warranty. If you're buying a home as is, you're buying a car with no implied repairs to be completed. So when someone is selling, you're buying a home as is, it just means that there's no predetermined amount that the seller is going to pay for any repairs. So those are things that you want to know. Other disclosures, moving on past condo, we have our agency disclosure. So we have a buyer disclosure form, buyer brokerage form, a seller disclosure form, in which you hit on earlier. We don't talk about school zones. We don't talk about crime. We don't talk about sex offenders. That's Megan's Law. There are resources available. They can look it up on their own. We can't tell them if other Jews live here so they can be amongst friends, or if this is a Puerto Rican neighborhood, or whatever. We can't talk about any of that stuff. That's a different conversation for another day. In discrimination, and how sometimes being helpful can go really sideways on you, or trying to be helpful can be going sideways. Affiliated business disclosure, we are affiliated with a title company, so you want to make sure that you're giving them that disclosure, letting them know that that there is a relationship that exists. That is something that is required by federal law to do. PACE disclosure, who can tell me besides Ted what a PACE disclosure is? I forget what it stands for, but a PACE disclosure is a lien against the home that is tied to an energy improvement. And so there was a program that the government released that said that they could charge energy improvements to their tax bill. And so, for example, new windows, solar panels, things of that nature, you wouldn't have to pay for it as like a monthly payment, but they would just add an extra like $4 or $5 grand to your tax bill. So you just pay that extra. So it's just a way of hiding the payment so it doesn't look like you're spending the money. And because it's on your tax bill, it becomes a write-off, and so people do that. Now, what happens is you must disclose that a PACE lien exists on the home, because in some cases it must be paid off before the closing can continue, because it is a lien against the house, and the lien must be cleared ahead of time. Now, if it's a cash transaction, that might be a little bit different. The lien could be assumed, perhaps, but if it's a mortgage situation, the mortgage is always in the first position of a lien. And so you want to make sure that gets cleared up. So when you're listing a home and you notice they have solar panels or new windows, or even if you don't notice it, just ask them if they have a lien or for any improvements that have had. And then there's a form for that. Licensee interests. So if you are selling your own home, or the home of which a reasonable person in the general public can assume that you have ties to directly, you just want to give them this licensee interest disclosure. It is literally one sentence on the form. It says, I, Richard Albazar, may have an interest in this property. So if it's your parents' home or your daughter's house, or it's your own home, you just want to have that on there to protect yourself. And then on the contract, so I just sold my own home, and I had to make sure I had the disclosure in, and then on the contract, or in the MLS, I put it everywhere. I am the owner of this home. I am also a licensee. That way everybody knows. Most of the time, nobody cares, but some people feel duped if the agent is also the owner, because they feel like they could have gotten a different deal, or they're getting a worse deal. And so that's something you must disclose. Radon. How many of you know that we are required by law to disclose radon in a home? We must, every single file, every single closing must contain a radon disclosure. Who has submitted the radon disclosure with their properties, with their files? Anyone? Has anyone submitted the radon disclosure?
Isn't it for basements though? Basements? Or-
Radon is more prevalent in basements, but is naturally occurring in rock. So has everyone filled out their radon disclosure when they've submitted the contract? The answer is yes, you have. Trick question, gotcha. It is
Is it
included.
in the contract?
It's in the
Yeah,
contract.
it's in the contract itself.
It's included in the contract itself. LBP, yeah, you know me, is lead-based paint. Homes that are built prior to 1978 require, by federal law, a lead-based paint disclosure. It must be signed by you, the licensee, the buyer, the seller, and the agent on the other side. And that is, yeah, every residential listing, every lease, everything has to have it. It is assumed that any paint that was put on before 1978 has lead in it. And so there may remain some chips, something somewhere. So that must be included. If the home was built in 1978, then you're fine. It's just homes that were built prior to January 1st of 1978 must have it. Next question. You have a listing. You go under contract, buyer does inspections, buyer walks, but for a non-inspection reason. Buyer walks because they have a change of heart. They really want a home with a pool. Yours doesn't have a pool. What happens to that inspection? They give you a copy of the inspection report. What then? That report becomes part of the listing.
Okay.
Because
Do you
And
have
he
to
typically
upload?
posted?
No, you're good. Do you have to upload the entire report or?
you should.
Yeah.
So you protect yourself the most by uploading everything you have. It's not for you to determine what's important or not. An inspection report. Any kind of hiding is where fraud comes into play. Why did you hide this one page? I didn't think it was important. Okay, that's just silly. Just upload the whole thing. Also, there is an addendum to the seller's disclosure. There's a 5th page to it. That's usually the page that has all the lines on it that are blank. That is specifically for anything that comes up later, you would put there. And right on there that to see inspection report performed on such and such a date by such and such inspection company. And then that is now an attachment to the seller's disclosure and everything is there. And then you are perfectly ironclad. And if you're smart, you spin it in a way, if you disclose everything there is to disclose, then it's baked into the price. People can't come back for you later and try to nickel and dime you on the inspection report because it was already disclosed ahead of time. So there is a very smart way of using that information. It is what it is. Look, if the information is unfavorable, if it sucks, it's still gonna suck no matter what. The best thing to do is to attack it head on. In some cases, you have sellers that insist on doing some repairs ahead of time. That's completely up to them, what they want to do, but you need to disclose the whole thing no matter what. But then make sure everyone refers to it and let them know that, you knew that information when you made your offer, so we're not going to negotiate anything. Now, the next buyer can still perform their own inspection. There's nothing that says the next buyer can't do their own inspection, and the new inspection report might yield things that the first inspection report didn't find. Again, that's fine. That's not your problem. You weren't hiding anything. The inspector that did the report wasn't hired by you. They were hired by somebody else. You're just passing along information. So that's what you do with those inspection reports, always, all the time, no matter what, because when I tell sellers, it's a gift. Someone has paid hundreds of dollars for this information, and now it's ours. It's your house. Like, now it's ours to do with it what we can and try to get ahead of it. Next thing I want to talk about disclosing is price. So price, if you receive multiple offers on a home, are you allowed to disclose to agents what you have? I have 4 offers. You are agent number 5. You call me, hey Richard, I want to make an offer. I say, I got multiples, just so you know. You will naturally ask me, what do you got? Just try to poke around a little bit. What do you got? I can share it with you and be perfectly fine if, what?
If I have the seller's permission.
Yes. If I have the seller's permission, I can share whatever I want.
Okay.
The default is no, we don't share. So
I never do, but.
we don't share unless we have the seller's permission. Because some would argue that it's in the seller's best interest to share what you have. And it's up to them to decide. And then you can give them the pros and cons of both. You know, the pros and cons of having a blind process or having a process that's more transparent, which one will yield in a better situation. So that was all about disclosure.